Good afternoon, everyone. Thank you for joining us for this episode of Stewarts Soundbites. Today we're going to be discussing medical negligence abroad. This is pre-recorded, so we can't take any questions today, but we'd be happy for you to contact us afterwards if you do have any questions. So here at Stewarts, our clinical negligence team is well known for representing clients who've suffered life-changing injuries as a result of negligent treatment here in England and Wales. But within our team, we also represent people who've suffered these sorts of injuries abroad. We are very lucky today to have Ian Denham from Outer Temporal Chambers join us. Ian is a personal injury and clinical negligence practitioner with particular expertise in matters involving serious and catastrophic injuries, wrongful death and accidents abroad, and he has a particular interest in cases with an international element, which makes him an excellent guest for our talk today. So welcome, Ian, and thank you very much for joining us.
Thank you for inviting me to join you.
To start us off, and the title of this episode will probably give this away, but can I ask you to explain what a cross-border clinical negligence case is?
Yes, and it's hopefully a relatively simple answer. In simple terms, it's a legal case where somebody has suffered an injury arising from clinical negligence abroad. That could also be somebody who is in the United Kingdom but lives abroad and suffers is a victim of clinical negligence here. So effectively, it's clinical negligence with an international dimension. So in terms of where the cases can be pursued, they can either be pursued in the place where the harm happened, the place where the responsible party is based, that might be the doctor or the hospital or another clinician, or in certain situations, and obviously this is of more interest for those who have been injured abroad who are based in the UK, is on certain occasions those cases can also be run back at home, either in the courts of England or Wales or one of the other UK courts.
And so following on then from that, what sort of circumstances give rise to a cross-border clinical negligence case?
A great many of different circumstances, but I think the starting point is it starts in a clinical situation. So although we're talking about international cross-border cases, international clinical negligence cases, they still remain clinical negligence cases. So they tend to arise in a number of different circumstances. Starting off with probably the most common is where people are seeking medical treatment abroad. We've all heard of the growth of cosmetic tourism cases, and there are a large number of individuals now who will travel principally for money-saving purposes to different countries to have various types of cosmetic procedures, but they are not all. And although they grab the headlines, there are also a large number of individuals now who will, either through expediency by wanting to have treatment sooner, or by trying to reduce the costs of private surgery, will look to travel to various locations in Europe and very often beyond to have that treatment. And that's the obvious ones, and they're the ones that often get the attention in the news. The other category of people is far more ordinary and is probably more likely to affect the normal person. And that is the person who happens to be abroad and for whatever reason suffers an illness or has an accident and attends a local hospital, whether or not that be on a private basis or on a private basis, and undergoes medical treatment there. And it's very common for issues to arise in those hospitals, as it would be if they attended an NHS hospital in the UK. So there can be quite a varied set of causes for how people are seeking and requiring medical attention abroad.
Yeah, in terms of those medical tourism cases, they're, of course, as you say, the ones that hit the headlines, and we frequently see people who've been to Turkey, for example, and things have gone wrong when they've gone abroad. And I guess when you're going abroad for medical treatment, whilst you don't expect it to go wrong and you're hoping that it will be okay, it's more within your anticipation, I guess, than somebody who's on holiday. The more everyday trip on holiday and you either have an accident, a fall, or unfortunately you have some kind of medical condition which requires some kind of treatment. And then you end up in hospital abroad, and then you end up having treatment there. I think those are the ones which, it's the more everyday thing. It's completely unexpected. And those are the ones that at Stewarts I come across more often than the medical tourism ones at the moment, because as I've said, because we're doing those sort of catastrophic injury cases, they tend to be the ones where somebody unfortunately has just become ill or had an accident and then treatment on holiday. And it is quite frightening what can happen. And it's so stressful for the client and for their family, because you're abroad, you're away, you need to get back home, or you want to get back home to get treatment here and be back where you know. So I think it's so important to be able to know if you've potentially got a case.
Absolutely. And just as a tangent, you can see the real significance of medical insurance in those situations as well, because those individuals aren't expecting something to happen. And depending on which country you're in, you can rack up such high bills, and there's costs of repatriation as well. So I really do feel for those people who find themselves in those situations. And it's fortunate that if they do, they're able to turn to Stewarts to be able to assist them in those cases.
So then, sort of following on from that, looking at the law then, so if we've got a client who's come to us and they've got a clinical negligence case, can you tell us a little bit about the law that applies in clinical negligence cases abroad, and what the key issues are that we need to be looking at and thinking about early on?
Absolutely. And in terms of an introduction to this, it really depends upon the circumstances which led to the negligence, and to a degree, the events which are involved in the negligence themselves. So if we start off by looking at a contractual situation, so this is not a situation where somebody has been unlucky and found themselves ill, or is unlikely to be. It depends on the circumstances. So a common situation will be, for example, somebody who is here already and is contracting to have treatment abroad. As with all contracts, the detail is in the text, and a lot, particularly those which are targeted towards people in this country's consumers, should contain an applicable law clause. And that's usually pretty binding, unless there are specific provisions within that applicable law that are particularly unfavourable to consumers, but that's pretty rare, and they're usually pretty draconian provisions there. If the contract does not include an applicable law clause, that might be in a consumer type situation or not, then within the UK's domestic law, as retained from when we were a member state of the EU, we have the Rome 1 regulations, and that will effectively set out a series of rules as to which law will apply in a particular circumstance. And the purpose of that regulation is designed to be foreseeable and predictable in terms of its application of what law will apply. So that will depend on the circumstances, but very often it'll be the law of where the action was taking place is typically the law that will apply. Of course, if we're looking at the situation where somebody is unexpectedly seeking medical treatment abroad, they've had an accident, they've fallen ill, and rather than being in a country such as our own, where there's a free medical health care, or there is free medical health care, but it's not something that they can rely upon, they may have to pay, and there may be a contract. And once again, that will depend on the clauses. However, if, for example, we've got somebody who's seeking medical treatment in Spain, it's highly likely that Spanish law will apply to that. So that's the first part, just contractual claims. Continuing on the theme of contract, we've then got package cases. Now, this is a growing area and much more fits into the consumer-led type of treatments that are being offered by various different entities abroad. This is always a contractual claim if it falls within a package, and just very, very, very broad terms. This will be where the medical treatment is included with either some travel component or some accommodation component, or both, in order to meet the definition under the 2018 travel package regulations. The good news for a consumer is this is a case that can be brought under English law, for a case brought in England, and will be brought before the English courts. So that will be very familiar. The only difference may well be, depending upon what representations are made, is with regard to the standard of surgery. So although English law applies, it may well be, for example, an argument would be raised that, well, the standard should be that of a reasonable competent surgeon in Poland as opposed to in England. And there might be a debate as to what the differences there are, but that will always be helpful, because that's a case that will always be able to be brought in the claimant's home court, as opposed to the contract case, which may well depend on where the contract was made. Although if it's a consumer contract, there is at least an argument that it can be brought here. The final situation is tort. So this is really when there's not a contractual relationship, and that's a situation, Vicky, that you were focusing on earlier. When somebody goes to a hospital, there may not be a contract, and the argument is that the standard of treatment fell below a reasonable standard. In that case, the applicable law will be determined by what's called the Rome II regulations. And that effectively, in a nutshell, says that under Article 4.1, the applicable law will be the place where the harm was incurred. And it's pretty hard to imagine any other law applying. Articles 4.2 and 4.3 do make alternative provisions, but really, unless it's an unusual case, usually you'll be looking at the law of the place of the harm, which will apply in those cases. So very much depends on when the surgery took place, and why.
And I guess, as you were saying there, then quite often the foreign law is going to be applicable in those circumstances. That opens us up to a lot of potential pitfalls, really, because as lawyers usually working in England and Wales, we're very used to all of the legal issues that arise in clinical negligence cases in England and Wales. We need to be mindful that there are different laws that apply under foreign law, and there are different limitation period, for example, but different issues that are arising. So when we've got those foreign law being applicable, what are those kind of key issues we need to be identifying and making sure we're looking at really early on?
The first was the one that you just alluded to, and that's limitation, and that really is crucial. And you should never make any presumption as to what the limitation period is. Some countries, as I know you're very familiar with, one of the cases that you've currently been running is Spain, and Spain has a very limited limitation period. But people can fall into a trap, as I know you're very familiar with, that although the limitation period generally in Spain is 1 year from the date of stabilisation of the injury, and it can then be extended almost infinitely. In certain medical situations, that can't happen. And the limitation period may be one period of time for a claim against one type of entity, maybe a commercial entity, and a different period of time if you're focusing on against an equivalent to the National Health Service. So that is absolutely essential. And that's really, as I know we're going to be getting on to, one of the things that prospective claimants really need, one of the reasons they really need to seek legal advice as soon as they can. Other issues, again, can be quite surprising. Liability will be determined by the applicable law, and there may be issues, for example, as to what the standard of proof is. In England and Wales, it's the balance of probabilities. But through my experience, the laws in other countries can have a far higher standard to be able to prove, which can again make the cases very different, and will have an effect on what evidence you need to get to support that case. And I think, although there's much more I could talk about, the other one just to raise is the valuation of the case. What heads of loss are recoverable and how they are quantified will be determined by the applicable law. And certainly in my experience, there are very many claimants who find it very surprising when you go through and explain how the losses are quantified, and they can be really very different. and will very much affect what medical evidence you want to get to support, particularly in the case of condition and prognosis reports.
Mm-hmm. Thanks, Ian. Yeah, the last point I kind of wanted to conclude on before we wrap today up was to look at what should someone do if they think they might have a cross-border clinical negligence case. And just to reiterate, that could be having gone abroad to seek medical treatment and something's gone wrong, or from being away on holiday or work and seeking medical treatment there and something has gone wrong unexpectedly in terms of the initial injury, but then obviously unexpectedly once something's gone wrong. And I think that's probably for me just to say, seek legal advice as soon as possible for the main reason you've just highlighted, which is limitation. It's not as clear cut in every country as it is sometimes here. We have a relatively strict limitation regime, and it doesn't change dependent on the defendant in the case or the type of clinical negligence case, but in different countries it does, and so it's important to seek early legal advice to see if there is a case. You need to be able to go to a solicitor who's going to be able to liaise with counsel in a different country, because you need to be able to get the advice on limitation primarily, of course, but also you need to look at liability and quantum, as you've talked about there, and also funding is the other issue we haven't touched on today, but you need to work out how the case is going to be able to be funded. And so if someone does think they've got a case, it's really important they seek legal advice from somebody who's got that kind of experience as early as possible. Is there anything else that you'd like to add to that, Ian, or do you think we've kind of covered it up there? Yeah, brilliant.
I couldn't have put it any better myself.
Excellent. Well, in that case, it's just for me to say thank you ever so much, Ian, for joining me today. Sorry that we're unable to answer questions live, but both Ian and I are happy for you to contact us after the webinar with any questions about clinical negligence abroad or anything that we've discussed today. Thanks very much.